So first and foremost, it's a great pleasure to be speaking with three of my terrific colleagues, Brad Berman, Rob Flanagan, and James Taylor. By way of background, I'm David Bax. I'm a partner in Mayer Braun's corporate and securities practice and have been, capital markets lawyer for about 25 years. And during much of that time, I've had the opportunity to really work on many MTN programs, all over the world, including ones that we work on collectively as a group, the four of us, for issuers and investment banks all throughout the world. Just by way of background and turning to the first slide that talks about the deal structure and process, medium-term note programs actually came out of the commercial paper market, and they were really designed to fill the gap between very short-dated commercial paper that typically had a maximum maturity of 9 months or maybe 397 days, and really the shortest maturity of underwritten debt securities, which at the time that the product evolved was somewhere in the area of 3 to 5 years. When these programs were set up, they were envisioned in many respects like the commercial paper programs, whereby you have continuous offerings and you have continuous offering procedures, and that way it would enable issuers to access the market and meet their corporate financing objectives. Again, in those terms that I just mentioned, in a way that was very, very advantageous to them. Initially in the early years, and lawyers at Mayer Braun were involved in some of the earliest MTN programs. These programs were really designed for people who had, auto finance platforms, other, platforms, other corporate issuers, whereby the ability to be in the fixed and floating rate markets, at any point in time when there was a market window or a market opportunity was very, very attractive. Again, finance companies were initially dominant in the early years, but at the present time, we see offerings by everyone from every type of Fortune 500 or its equivalent around the world to large pension funds, asset managers, and everything in between. The idea is that once these programs are set up, there is an ability to quickly access the market whenever there is a market opportunity. And when you set these programs up, a set of deal documents are negotiated and executed that set forth the framework for these programs, but that once that's up and running, you can have very, very rapid trades, oftentimes on a benchmark size, a lot of times on a smaller private placement size. Some are syndicated, some are not, and really provide very, very significant flexibility. Now, I'm coming to you from primarily a corporate finance background. My colleague, Brad Berman, who also has a similar background, he, in addition to doing all of this, will talk and is very experienced with the structured notes that are also done off programs for all sorts of issuers, including bank issuers and other issuers. And the infrastructure for both of these things overlaps to a great extent, but there are quirks and nuances as between a corporate and a typical deal. So turning to the next slide, which talks about the offering documents. The offering documents are really designed to have something that's similar to an offering. It has a base prospectus. It has a prospectus supplement. In a product, it may have a product supplement, but this typically describes the terms of the securities. So turning to the next slide. So the issuer in a program will typically engage multiple agents. And once they set up that infrastructure, they can really go out and be in the market through any one of those agents at any point in time. So next slide, please. In the structured world, a lot of times the underwriter is an affiliated broker-dealer of the issuer. For corporate issuers, that is really rarely the case. And there are lots of differences. I mean, if you think about it, between having, for example, an HSBC or a JP Morgan go out and issue their own notes, even if they're whether they're structured or whether they're their own, or a corporate finance issuer going out, corporate or other issuer going out and issuing notes into the market. I think on the next slide we've talked about just in terms of the distribution of the securities themselves, in terms of how they're set up, and in terms of the roles for some of these things. One of the things to just come back to about the offering document is that when you're offering securities, whether on a one-time basis or on a continuous basis, you are giving an investor sufficient information at the time of sale so that they can make an informed investment decision. And so in an offering, in a one-off offering of securities, you're typically going to have, an offering document that's very substantial and robust. Speaking as of its point in time, you'd have a preliminary, and then you'd have a pricing term sheet, and you'd price that offering. In the medium-term note context, what you'll have is a base program offering memorandum or a base program prospectus, and that will have the latest issuer disclosure. Depending on the profile of the issuer, that disclosure may be included. There are ways to incorporate reporting issuer or other large issuer disclosure by reference. But one way or another, we have to have a continuous mechanism so that by the time the investor makes their investment decision, they have sufficient information for them, to make a decision on the basis of a disclosure package that's free of material misstatements or omissions. The terms of the distribution agreement typically mirror, in many respects, the terms, of an underwriting agreement or a purchase agreement, with the key differences being that when you set up a distribution agreement, you're really setting up something that can, exist for many years with offerings from time to time, and it covers things like requirements for periodic updates. It covers things like, delivery of officer certificates from time to time, opinions, comfort letters, and that sort of stuff. We did put in the appendix to these materials, a timetable and other sample things about MTN programs. The distribution of labor among the working groups typically does fall along the lines of what you would have in a one-off offering. So, the key disclosure document would be prepared by the issuer's counsel in terms of issuer disclosure or issuer and guarantor disclosure. The underwriting sections, and the distribution agreement and the negotiation of a comfort letter and things like that would all come out of the agent's counsel or the underwriter's counsel. Turning to the next slide, just on risk factors. So, whether it's a program or whether it's a one-off offering, the risk factor disclosure again needs to be very consistent with starting with really what you would have in a registered offering, and obviously if it's registered, you would comply with the SEC's requirements there. The one thing that we're seeing a lot of interest in now, and frankly one area where I'm constantly engaging with Brad Berman in particular, has to do with the uncertainty about the timing of LIBOR replacement. And so that's a constantly evolving area, and I know Brad's going to talk about that when we come to him. But at this point, I'll turn it over to Brad actually to start off with talking about Section 3A2 offerings and offerings by banks. And then I think later on in his materials, he's going to cover issues with benchmark replacement as well.
Yeah. Thanks so much, Dave. Appreciate it. So on the next slide, we'll start on really what are called banknote programs, a subset of MTN programs. And these are, banks have the advantage of having an exemption from registration under Section 3A2 of the Securities Act for securities issued or guaranteed by a bank. The reason that's there is basically banks are already under a lot of regulation. They do a lot of disclosure. They have capital requirements. The concept is they should be able to pay their debts. They don't need to overlay federal securities registration requirements on top of that. Next slide, please. But the thing is you have to be a bank within the meaning of the statute. So what's that? Well, you're a national bank or a state bank supervised, and your business has to be substantially confined to banking. There are a number of entities that sound like banks that don't qualify, like bank holding companies, finance companies, investment banks, non-US banks. But regulated US branches and agencies of foreign banks may qualify. We'll talk about that in a moment. Next slide. Guarantees is what I read from the exemption. It said a security issued or guaranteed by a bank. Guarantees are really big. And what this is it's not limited to a guarantee in a legal sense, but it can include other arrangements in which the bank agrees to ensure the payment of a security, like a letter of credit. It's got to be full and unconditional. Guarantee by a foreign bank other than their US branch wouldn't qualify because that's not a guarantee by a bank. They're really a legal requirement. When you do an issuance, for example, of a note that's issued by the non-US Home Office with a guarantee by its US branch, which would satisfy 3A2, if something goes wrong, investors are going to look to the Home Office, not the branch guarantor. This is how finance companies and other non-bank type issuers can use 3A2 if the securities are guaranteed by a bank. Next slide, please. So how did these non-US banks, US offices, get in to qualify as a bank because they're non-US banks? Well, in 1986, the SEC took the position that essentially a foreign branch or agency could be deemed a national bank or a banking institution organized under the laws of any state or a state bank. Essentially, if the nature of the federal and state regulation or supervision of that branch or agency is substantially equivalent to that applicable to federal or state chartered domestic banks doing business in the same jurisdiction. So we see many U.S. branches and agencies of foreign banks. They're frequent issuers or guarantors of debt securities in the U.S. Most of these branches are New York branches for the ones who have opted for state law. A lot of these branches are national banks. They're supervised by the OCC. Next slide. And Dave kind of covered this, just basically the FINRA issue. This comes up a lot because most bank holding companies with subsidiary banks have a captive broker-dealer, so you're looking to make sure that the issuer has outstanding investment grade rated unsecured non-convertible debt with a term of issue of at least 4 years, or you rate the debt securities as investment grade. Also, the affiliation raises what FINRA calls a conflict of interest. There has to be prominent disclosure of that. And again, you're looking for an investment grade exemption for the banknotes or ones in the same series to avoid having to appoint a qualified independent underwriter. And just note that 3A2 banknote transactions and Rule 144A, which Rob will cover, are both reported in FINRA's trace system. Next slide, please. So the big news, and this is really going to affect all MTN issuers in the US, is the new 2021 ISDA definitions. And effective October 4th is going to be a new main book and their annexes. And the one we're going to focus on today is the floating rate note matrix. And currently, when you flip open an MTN description of notes, you're going to see all these descriptions of the rates that are essentially copied out of the 2006 ISDA definitions. And essentially, they will all be wrong. They'll be wrong to the extent, I mean, commercial paper and federal funds, that's not going to change. They're a rate you see on a screen, a Reuters screen, or H15 or a Refinitiv screen now. That doesn't change. But what has changed, and we'll talk about in a moment, is the fallbacks. Those are going to have to be rewritten. LIBOR, SOFR, and to some extent CMS, those have really been updated over the past couple of years because obviously LIBOR is going away. So you have that with the ARC fallback. SOFR, the ARC has come out with a number of kind of model term sheets people are using, and CMS, people have kind of gone through that because they know the LIBOR the LIBOR floating rate leg is going to go away, and most issuers have added appropriate fallbacks. There's some new rates in the floating rate note matrix that are becoming popular now. There's a MIFIR, the Bloomberg Short-Term Bank Yield Index, or BSBY, S&P Index High Grade, SOFR obviously is in there, overnight bank funding rate, which is more known as a SOFR fallback, but those are also included in the matrix. Next slide, please. So how are we going to draft? As I mentioned, the old way, you just copied your description out of the 2006 ISDA definitions. That was good. You can't do that anymore. The 2021 ISDA definitions do not have descriptions of the rate in them. What you have to do is enter the matrix. You take the red pill and you start going through the charts. And when you see the matrix, there's lots of columns, lots of tiny font, but when you break it down, it's pretty logical. When you start going through it, you'll see most of the first group of columns are just simple identification of the rates and whether they're overnight or term rates, and then they kind of divide it up, like where do you get the rate? There's screen rates. Obviously, you read a rate off a screen, including H15, which is the Federal Reserve daily published rates. And then there's what they call calculated rates, which involve a calculation. And as most people know, Fed funds, US Treasury bill rates, you have to run the rate through the money market yield and bond equivalent yield formula. Interestingly, CMS is not included in the matrix. Next slide, please. So as I mentioned, the big change is there is no more polling. The 2006 ISDA definitions had the old, you can't get the rate, you go get quotes, you try and get 4, you can't get that, you get 3, then you end up going with the old rate, bingo, you're in a fixed rate note. Obviously, everybody knows that's caused a huge problem with LIBOR, so nobody wants that anymore. Even though reference banks is included in the main book as an option someone could choose, but it's not in the matrix. So what are the fallback situations that are covered? First of all, there's what they call a temporary fallback, which is, you flick on the screen, I don't know, there's a power outage at Refinitiv that day or something, you can't get the rate. That's a temporary cessation. So the answer to that is the standard temporary non-publication trigger. What that is just go to the previous day's rate, very simple. What if there's a permanent cessation? So what is a permanent cessation? And that is what they call an index cessation event. And we've seen that is the same thing that's in US dollar, LIBOR, and SOFR. 2 to 3 parts. The first 2 parts are public statements by the administrator or the regulatory supervisor for the rate that there's going to be a cessation. USD LIBOR has a third option that the regulatory supervisor says the rate's no longer representative, even if it's being published. That's the old fear of zombie LIBOR, maybe only 6 panel banks submitting quotes, and it's not really strong enough. So that's your permanent cessation. Next slide, please. And the last option, which is a new one, is what they call administrator benchmark event. This is essentially impracticability. You get a notice from the issuer or the trustee that under law or regulation, it's illegal to continue using the rate. What do? And what they have is they have these generic fallback provisions that you would choose in advance. And by the way, on the previous slide, when I talked about permanent cessation, if you have an index cessation event, that you end up, the next step is you're at these same generic fallback provisions. There's 5 choices here. I'm just going to talk in the context of floating rate notes because we're in an MTN seminar, but these would be 5 things an issuer, the parties could choose, and only one of them really works for floating rate notes. So there could be agreement between the parties. That's not going to work for a floater. Application of alternative pre-nominated index. I think that's going to be the winner here, and I'll discuss in a moment why. Application of alternative post-nominated index. No, nobody's going to start arguing about what replacement when the note's already out there. Calculation agent nominated replacement index possible, but I think a lot of calculation agents aren't going to want the responsibility, and no fault termination, no. So I think the pre-nominated index will work, and what we will see is issuers are going to include a fallback rate in their offering documents under the rubric of the alternative pre-nominated index. So for example, if you went out with a Fed funds floating rate note and for some reason Fed funds permanently ceased, you would look at your offering document. Oh, okay, we see the alternative pre-nominated index is SOFR or commercial paper or something like that. So I think that will be the workable solution. The goal of this, according to the ISDA definitions, is to get to an amendment to the floating rate note that allows it to continue under the new rate. So they're trying to avoid what happened with LIBOR, where you had fallbacks that didn't work and there's not really good solutions, and we're passing laws to resolve it. So anyways, that's something we're going to have to look for. I think we're going to see a lot of revisiting of our current MTN programs as it sinks into people's heads that come October 4th, there's going to be a very different disclosure regime out there. That's all I have. I'm going to hand it over to Rob Flanagan to cover 144A.
Thanks, Brad. So I want to run through the 144A market and legal framework. So 144A is the exemption from registration that applies to sales to institutional investors. It's a very sizable chunk of the U.S. bond market. Anywhere between 40–50% of the bond market, and it has a lot of advantages for issuers, and especially issuers who aren't eligible for the 3A2 exemption that Dave was talking about. That's applicable to banks. So the advantages of 144A: you don't have to register your prospectus with the SEC. You don't technically have to prepare a prospectus, though typically the issuers would anyway. As a general matter, the 144A market is for larger benchmark issuances. So I think the average issuance in the 3A2 market is in the hundreds of millions, and the 144A market offerings are typically more in the $400–500 million size. So that offers good liquidity for wider marketed transactions. And U.S. banks, even though they do not have to rely on a 144A exemption, often do for marketing reasons, and they want to be part of the market of qualified institutional buyers because that drives liquidity and investor interest. So the key concept of the exemption is who the investors are, and that is qualified institutional buyers. We'll go in a couple slides down into precisely what that means, but the key is large. I'm sorry, can you go back to that previous slide? Thanks. It is institutions, not individuals, no matter how wealthy they might be. And the fundamental concept of 144A is we have sophisticated investors with sizable assets whose professions are managing investments. They do not need the protection of the SEC registration process in order to make their investment decisions. They are able to demand from investors the information they require to make an investment decision. As a reminder, the 144A is an exemption from the registration requirements, i.e. creating a prospectus. It does not exempt issuers from or underwriters from liability provisions, i.e. if there are false information that's in the market or that is given to investors at the time of the placement, the issuers and underwriters can still be liable for those misstatements or omissions under Section 10B and Rule 10b-5 of the Securities Act, Exchange Act. And the other key characteristics, which we'll get into shortly, are the exemption is not directly available to issuers of securities, but rather to resellers, which typically means underwriters. It can also mean, in the case of equity, for selling shareholders, but it is not an issuance exemption directly for issuers. It does not apply if the securities are already listed on a U.S. exchange or NASDAQ, effectively an interdealer quotation system. And it's not exclusive, meaning that an investor, an issuer can rely on 144A, but can also rely on other exemptions for all or part of the placement, including Regulation S and Rule 144. And we'll look into those in the coming slides. Next slide, please. Thanks. So as I started to mention in the prior slide, the key elements are, this is a resale exemption to QIBs or at least investors that the reseller believes are QIBs. And the underwriters who are placing securities need to document and establish in reasonable belief that the investor satisfies the QIB requirements. The QIB is purchasing for their own account or on account of another QIB. In the case of investment advisors, the investor needs to be notified that the placement is done under 144A. As I said previously, the notes can't be issued. Now, that's usually not a question for MTN programs, because each issuance of notes would be a different class of debt securities for these purposes. It can be an issue for equity securities and or tap offerings where you're issuing new securities that are identical to listed securities. And the issuer can't be an investment company and various iterations of investment companies or unit investment trusts or the like. And there is an information requirement, not a prospectus requirement, but the issuer must either be an Exchange Act reporting company, i.e. listed with the SEC and sending out 10Ks and Qs, or 20Fs and 6Ks if it's a foreign company. It could be a foreign issuer that is listed on a non-US exchange and is exempt from reporting to the SEC under 12G32B. Or if neither of those cases apply, then the issuer has to undertake to provide certain information to investors upon their request. Next slide, please. So QIBs, the key number to keep in mind is 100 million. Fundamentally, a QIB is a corporation or partnership or any type of entity that has 100 million in securities of non-affiliates, so not group companies, but investment securities of $100 million or more. It can also be calculated as various entities that are advised by the same advisor. So if an investment manager has 4 or 5 funds that each have less than 100 million, but together have more than 100 million, that would also count as a QIB. Registered dealers, those are dealers that are registered with the SEC to provide investment brokering services and invest or own 10 million or more of securities. They can also invest on behalf of QIBs. And banks that have more than $100 million in investable assets can also be counted as QIBs. And you can create QIBs temporarily for one transaction. Next slide, please. So the key requirement for the underwriters or the resellers under the 144A is determining who a QIB is, and there are multiple ways to get there. They can get certification from a CFO, they can look at publicly available information, they can request questionnaires, they can look at information put out by rating agencies and all the rest of it, as long as they have established a reasonable belief. And that needs to be based on relatively recent information, the last year and a half or so. As a practical matter, every underwriter that's placing securities and every dealer under an MTN program will have a current list of QIBs that is maintained and updated in order to make sure that that's current, and they will go off of their internal lists. And the SEC has laid out procedures in order to make sure that information is maintained and documented correctly. Next slide, please. Legining. So ledgeting is one of the requirements that I mentioned earlier, which is investors, the PRIIPs, need to be formally notified that they are buying pursuant to a exemption from the registration requirements. That's relevant to them because the securities they're receiving will not be freely tradable. They'll be restricted securities, which means there are limitations on who, to whom, and how they can be sold. The way notice is given is the security itself will have a legend. Any offering memorandum will have a statement indicating reliance on Rule 144A. Usually there will be a confirmation sent to the purchaser referencing the fact that it's a 144A security, and U.S. registered securities will have a restricted CUSIP number. Next slide, please. So back on this current information, I'd said that I'd give you some of the details. So the current information an issuer needs to be able to provide to investors in order to meet the 144A requirements are a short statement about the nature of their business, which needs to be 12 months old, no more than 12 months old, and financial statements, which would be a balance sheet for a period ending no more than 16 months from the date of issuance, and 2 years of income statement info running up to that balance sheet date. If possible, if reasonably possible, the information should have been audited. And with that, the 144A exemption would be met. Typically, underwriters will require more recent information, issuers will want to provide it, and investors will demand more recent information, but this is the floor in terms of currently available information to satisfy the 144A requirement. Next slide, please. So as I said, this is a resale exemption, and that means the issuer will create the notes on the closing date. They will be sold momentarily to an initial purchaser / underwriter who will immediately resell and place with the qualified institutional buyers. These are often paired with a Regulation S offering, which is not the subject of today's talk, but the Regulation S is for sales of securities outside of the United States. And that's where you get the reference to a 144A Reg S offering. So that would be sold typically to institutional investors on both sides of the, well, across the world globally. From where I'm sitting in London, that would be on both sides of the Atlantic, but it's the same structure for Asia, and many things are done globally, including by us. And the QIBs will receive, as I said, restricted securities, which they cannot sell to the public. They cannot sell on a market, but they can resell pursuant to other exemptions or in transactions not subject to the Securities Act. So that would be sales principally to other QIBs. There's an active intra-QIB market for MTN notes. They can also sell it offshore under Reg S. They could sell pursuant to other exemptions from registration requirements such as Regulation D and the like, or they can hold the securities and sell them more freely after the 144A requirements are met. Next slide, please. So just to summarize some of the advantages, which I've alluded to over the course of our speaking, these transactions are cheaper and faster for issuers. You don't have to go through a registration process. You don't have to file documents with the SEC. You don't have to pay filing fees to the SEC. You do have issuers and underwriters have lower legal liability because this is not a registered transaction. They're not subject to Section 11 of the Securities Act, which imposes strict liability on issuers and liability on underwriters for errors in the offering documentation, material omissions or misstatements. You're subject to a similar but different and slightly less constraining liability provision under other provisions of the Securities Act. FINRA and compliance requirements are lighter, and I guess particularly for structured notes and more complicated securities, you have the advantage of limiting the distribution of the structure of the security. Obviously, a registered transaction, the securities will be publicly available on the SEC EDGAR site, and competitors and others will be able to see how the structure works, what securities underlyings might be referenced for structured notes, etc. And on a 144A transaction, that will remain confidential as between the issuer and the quib. Next slide, please. And just as a quick summary as to who is doing these transactions and who the participants are. So there will always be an issuer of the notes. As Dave was saying earlier, there may well be a guarantor. The investment banks will underwrite or place the notes pursuant to a dealer agreement, which will be entered into and updated on an annual basis and then drawn down on for individual issuances. There are usually two law firms. One will be for the company, one for the banks, and the trustee or the fiscal agent, who we'll talk about in just a moment, will have their own counsel, very often a separate team with the counsel that's advising the underwriters on the transaction. You'll have the company's accountants involved. The accountant will have done the audit, and they will deliver a comfort statement, a comfort letter, which will confirm that financial information in the prospectus was correctly drawn from the audited financial statements, and they'll confirm that they are still the auditors and haven't withdrawn their services for any reason, and will provide, diligence comfort to the underwriters as to the accuracy of financial information in the offering materials. Typically, there'll be two ratings for MTN programs. There will be a fiscal and paying agent or trustee, depending on governing law and structure chosen. They have similar roles in terms of managing communications and relationships among note holders with the company, handling payments of coupons and the like. The key difference being a fiscal and paying agent acts as an agent for the issuer, whereas a trustee has fiduciary responsibilities to the note holders. If notes are listed, there'll usually be a listing agent which will help coordinate with the exchange. The notes will be cleared through DTC in the US or Euroclear Clearstream in Europe. And every once in a while, there might be a financial printer. Financial printers aren't used anymore in Europe, and they're pretty rare everywhere in the MTN market, but that used to be a significant industry. The next slide is I will pass this on to James Taylor, my London partner, who's going to give you some information on European and UK aspects of MTN programs.
Thanks, Rob, and good afternoon to everyone. So we're going to spend a few minutes with you on topics that come up from a European and UK securities law perspective on MTN program establishments, updates, takedowns that are run predominantly by US counsel from the US, and for which it's expected that there will be a European offering predominantly on a Reg S basis, alongside usually a concurrent 144A or 4A2 private placement, as Rob has mentioned earlier in the slides. So we'll start by looking at the private placement exemptions available in the EU and the UK to ensure that no prospectus publication obligation arises by virtue of the offering of the MTN. We'll then take a look at marketing and financial promotion rules and restrictions that apply in the EU and the UK. Thirdly, we'll shift our emphasis a little bit to the makeup of the underwriting syndicate and certain key regulatory aspects that will filter through to the documentation drafting if there's an EU and/or a UK underwriting bank as part of the syndicate. And lastly, we'll consider ECB collateral recognition rules in the context of MTN and what that might mean for the structuring of the offering, from the status of the notes, the specified currency, the settlement and the holding structure, rating requirements, etc. Next slide, please. So we'll start here with looking at the EU and UK private placement exemptions. And these are set out in Article 1.4 of the EU Prospectus Regulation, or now post-Brexit in the UK, the onshored version of this regulation that has applied since Brexit. And the basic rule is that should there be an offer of MTN in the EEA or the UK, or should there be an EU or UK listing of the tranche of MTN on a MiFID II or UK MiFIR regulated market, then the prospectus regulation or the equivalent UK prospectus regulation for the UK may apply to the offering, and a prospectus may need to be drawn up and approved by an EEA and or UK regulator, which obviously takes time, potentially up to 3 to 4 weeks, and costs money for the issuer. So it may be something, you know, if the Reg S tranche is very, very small, that the issuer would wish to avoid. Unfortunately, the definition of offer in the prospectus regulation is extremely wide. It covers pretty much any sufficiently precise communication to any person on the MTN or the terms of the offering of the MTN. Next slide, please. Thankfully, even though an offer of MTN may be triggered in the EEA and or the UK by communication to any person, there are customary private placement exemptions which are set out in Article 1.4 of the Prospectus Regulation or the UK Prospectus Regulation. And these include offers to institutional investors only, who will in the main fall within the definition of qualified investors, which is set out in the Prospectus Regulation and the UK Prospectus Regulation. More usefully, perhaps, because it's much easier to police on an issue-by-issue basis, is the minimum denomination private placement exemption. And this provides that providing the minimum denomination of the securities is at least euro 100,000 or its equivalent in the specified currency at the time of the issuance of the tranche of MTN, then no EU or UK prospectus will be required. So this is one of the reasons why on US dollar offerings that are being offered on a Rule 144A and a Regulation S basis to international investors may typically be issued with a minimum denomination of at least euro 100,000 or in US dollar 200,000 or above. Next slide, please. So next we'll move on to the PRIIPs regulation and the UK PRIIPs regulation and financial promotion rules generally in the EU and the UK. And in general terms, European regulatory authorities regulate fairly heavily the marketing of debt securities, including MTN, to retail investors. But they often provide useful exemptions from marketing and financial promotion rules when communications are focused exclusively on institutional investors. The PRIIPs regulation, together with the UK's onshored version, mandates that certain types of structured notes must not be marketed or offered to retail investors in the EEA and the UK unless the retail investors have received the Key Information Document, or KID, ahead of their investment. Now, KIDs are highly structured marketing materials that must be presented in a predetermined sequence of sections, including sections titled, "What is the product?" "What are the risks?" and "What could I get in return?" "What happens if the offeror is unable to pay out?" "What are the costs?" etc. And this rigid structure of predetermined sequences is almost certainly helpful for retail investors, and it would aid them in terms of comparing across different types of products. But it does add to the complexity, time and cost for an issuer in preparing for an offering of securities. So the key question is, does the PRIIPs regulation apply to MTN? Well, the regulation itself defines PRIIPs extremely broadly as any instrument, whatever its form, where the payout on the instrument is subject to fluctuations because of exposure to reference values or to the performance of one or more assets which are not directly purchased by an investor. And that might indeed include certain types of MTN. Next slide, please. So there are categories of products that are expressly excluded from the PRIIPs regulation, such as securities guaranteed by an EEA member state. But plain vanilla MTN is not, unfortunately, on the exclusion list. What this tends to mean in practice is that MTN that includes a redemption feature, where the redemption price is determined by reference to the price or yield of a reference obligation, such as, for example, a classic make-whole provision, may bring the MTN, the relevant MTN, within the scope of the PRIIPs regulation. This means in practice that if such MTN were to be offered to retail investors in the EEA or the UK, a key information document would need to be prepared ahead of pricing. Given the debt capital market outside of the US is predominantly an institutional investor market, the solution that has been drawn up by trade bodies such as the International Capital Markets Association is to prohibit offers and sales to retail investors in the EEA and the UK entirely on institutional offerings of MTN. And you'll no doubt see in your MTN offering circulars and prospectuses prohibitions on sales to EEA and UK retail investors for this very reason. Now, there was a hope that the EU Commission and ESMA, the European Securities Markets Association, would clarify that the PRIIPs regulation was never intended to cover plain vanilla MTN with a make-whole feature, given the potentially long-term detrimental effect that has been done by this lack of clarity in the regulation to the retail debt capital markets in Europe. It is, from the UK's perspective post-Brexit and the newfound powers that the Financial Conduct Authority has in the UK, it is anticipated that the FCA will use these powers to clarify the scope of the regime to exclude plain vanilla MTN with a make-whole feature from the UK PRIIPs regulation. But that, of course, will not apply to the other 27 member states of the EEA. Next slide, please. In addition to the PRIIPs regulation, the UK has a financial promotion regime in Section 21 of the Financial Services and Markets Act 2000. Communicating an invitation or inducement to engage in investment activity in the UK, so making a financial promotion, may be a criminal offence and may result in the investment transaction being unenforceable unless the financial promotion has been approved by an authorised person. That's a person that is on the FCA's register with a Section 19 authorization to engage in investment activity, or the financial promotion which hasn't been approved by an authorized person is an exempt financial promotion. Next slide, please. Now, in most cases, given the tight execution timetable on an MTN takedown, there'll be no time for an authorized person to review financial promotions against the FCA's conduct of business rules, which can be a costly affair as well and involve potential liability to an authorized person if they got the approval process wrong. So given again the institutional nature of the debt capital markets in the UK, the parties to a transaction look to ensure usually that their financial promotions fall within an exemption from the UK financial promotion rules. These exemptions include financial promotions that are communicated only to investment professionals and or high net worth companies and individuals. So once again, you may spot legends in launch announcements, term sheets, offering circulars, underwriting agreements, and so on, that outline the needs to comply with the UK financial promotion regime. Next slide, please. We now shift our emphasis to two items that may apply should an EU or UK bank be part of the syndicate of underwriting banks on an MTN takedown under the programme. Firstly, let's look quickly at the product governance regime. This applies to all investment firms in the EEA and, importantly, to branches of non-EEA investment firms. And a similar regime applies in the UK post-Brexit. The objective of the regime is to ensure that EEA and UK investment firms which manufacture and distribute financial instruments act in the client's best interests during all stages of the life cycle of the financial instrument. So an EEA or UK investment firm, or indeed an EEA or UK branch of an international investment firm that acts as an underwriter on an offering of MTN, must determine whether it is a product manufacturer under the MiFID II product governance regime, which applies generally to EEA investment firms, or the UK MIFIR product governance regime, which applies generally to UK investment firms. Occasionally, an investment firm may elect to comply with both regimes. For example, a UK branch of an EEA investment firm that acts as an underwriter on a particular takedown. In summary, the product governance regimes mandate that firms will be product manufacturers if they create, develop, issue, and/or design a tranche of MTN or advise a corporate issuer on the launch of a tranche of MTN. This is, of course, not a particularly helpful definition, but the market in Europe has tended towards the starting or default position that lead managers on a takedown will be product manufacturers and co-manufacturers will not. However, each underwriter that is incorporated within the EEA or the UK or is an EEA or UK branch of an international investment firm must make its own separate determination on an issue-by-issue basis. Next slide, please. So a European product manufacturer under MiFID II or a UK product manufacturer under MiFID II as onshore in the UK, so-called UK MIFIR, has certain obligations to satisfy on a takedown under an MTN program. As part of the approval process for the MTN, product manufacturers must specify an identified target market of end clients within the relevant category of clients for each financial instrument. So, for example, is the identified target market professional clients only or professional clients and retail clients as categorized according to their requirements under MiFID II or UK MIFIR. The product manufacturer must also provide sufficient information to distributors about the identified target market, and so that the distributor itself can understand and sell the product properly. The product manufacturer must also review products on a regular basis, discussing the distribution with distributors, so there must be a feedback loop that exists between the product manufacturer and distributor, so that the manufacturer can assess whether the product remains consistent with the needs, characteristics, and objectives of the identified target market. And the product manufacturer must also outline in writing to non-EEA and UK issuers and other parties that are subject to the underwriting agreement their responsibilities under the product governance regime. In practice, this has meant that for institutional offerings of MTN, standardized MiFID II letters to non-EEA and UK issuers that outline the EEA or UK underwriters' MiFID II or UK MIFIR obligations are sent out before pricing, and standardized legends disclosing the identified target market for the MTN is professional clients and eligible counterparties only, so institutional investors within the categories of MiFID II are effectively legended in summary or in full on term sheets, announcements, and in offering circulars and prospectuses. In addition, underwriting agreements often include the outline of responsibilities of product manufacturers under the regime, with the other parties to the underwriting agreement being required in the underwriting agreement to acknowledge these responsibilities of the product manufacturers. Next slide, please, and I'll now hand over to Rob to address the following slides.
EU banks and English banks need to provide in all of their contracts that their liabilities under the contracts can be written down in the case they enter into a resolution procedure because they're beginning to fail. And if either of EU banks, EU underwriters, English banks or English underwriters are entering into New York law MTN programs, they need to include a contractual provision saying that their counterparty acknowledges that the liabilities of the EU or English institution can be written down or converted into equity rather than being settled in full. And that is enough for today's class, though we could spend a lot more time on that if we wanted to. And then the other topic, if we can go to the next slide, to touch on very briefly, an important mechanism is a feature of EU MTN programs is collateral eligibility. So the European Central Bank has a system to lend money on the basis of posted collateral, and most MTN programs are designed that the securities can be posted by the investors to the ECB and used as collateral for lending. The characteristics that are required for a security to be eligible as collateral is the issuer must be an EE, be incorporated in the EE or in the G10 and approved. The debts must be senior. They must be not denominated in euro, though currently they also accept dollars, pounds, sterling, and Japanese yen. The notes have to be listed in the EEA or a couple non-regulated markets, but mainly a listed market in the EEA. And they have to be settled through effectively through Euroclear and Clearstream, and they must be issued in a particular form that was created about 10 or so years ago, which would be new global notes or registered notes that are in an agreed form that is slightly different from historic forms in US style. And the securities have to be rated. Next slide, please. And though when an issuer issues securities, the issuer will present the final terms and the documentation to the central bank of the country where the securities are listed. So that's very often the Central Bank of Ireland or the Bank of Luxembourg. And they will approve the security, if you meet the criteria in 2 days to 2 months, they will, in 2 weeks, they'll come back to you and say that the security is eligible to be used as collateral, and it's listed on a database which is publicly available, and you can just pop in the ISIN for the security and see if it's eligible to be used as collateral. And I think that is going to cover this topic for today. So I'm going to just pass it over now to Dave Bax for some closing remarks.
I think if there's one message and key takeaway from hearing my great colleagues from Europe, from the London office, as well as from Brad Berman, is that while at one level the medium-term note product has been around for a long time, many programs, lots of hundreds of billions of dollars or more of issuance, but even as we look to finalize some of the programs and offerings that we have in our office right now, the four of us, constantly need to collaborate to keep abreast of all of these different dynamics, whether it's benchmark replacement, whether it's all the European things that we're talking about, developments on the U.S. security side. And the one thing that I promised my London colleagues I wouldn't even talk about, but I'll just throw it out there so that people know it exists, and then they can tune into other seminars and topics on point, which is the market abuse regulation and how do you manage that in the context of programs, and for things like that, which is critically important to understand. If you have listed notes, you'll have to turn into one of our other programs for that. So, this product is definitely one that's, very much transformed the landscape. Certainly not for everyone, and I think when bankers and transaction management folks pitch the product, one of the key things they talk about is, the frequency of issuances and balancing between the program update, upkeep costs versus market access. But hopefully you've come away with a good idea of what's involved in these programs. And certainly if people have any further questions, please feel free to contact any of us anytime. Thank you.